if I compare the nature of the transatlantic conversation of privacy to where it was only a few years ago, that makes me certainly very optimistic. I think it has become a much less ideologic conversation. I think we all agree on both sides of the Atlantic on the need to have a credible, serious privacy rules in place. I think that in the US, you are now facing, and therefore I hope one day addressing the same challenge that led to the adoption of a privacy law at European level, which is the risk of fragmentation. We were there 10 years ago. I mean, one of the main reasons for the adoption of the GDPR was that there were too much fragmentation and too many divergences, and therefore compliance costs amongst our, at the time, 28 member states privacy rules. We are, of course, very interested and observing with a lot of interest what happens at state level. Whether this will mean to lead to adequacy or not, I think we see that those rules are developed, reflecting, of course, some choices that are specific to the legislatures that adopt those rules, but those laws tend to be based on convergent principles, on converging rules, and also converging governance mechanisms. If we see also what is happening in California, I think that this should also lead to more cooperation on the ground between our enforcers and the new enforcers that either already exist, like in California, or will be created in other states. That can help a lot, because I think that if we want to have more legal certainty, we need to work more on cooperation in terms not only on enforcement, but also on developing, if not common guidance, at least a common understanding of some key or basic privacy principles. All of this can help a lot. I was very happy to see that there have been already a first dialogue between the new Californian enforcer and the European Data Protection Board. This is something we really want to encourage.